দুটো দিয়ে দেবে প্রিভিয়াস দুইটাই করছি So it's already afternoon. Good afternoon to all of you. Those who are watch or will watch. We have already discussed citizenship and other things. We shall discuss now the questions related to citizenship. Then we shall proceed to fundamental rights. New chapter today. Okay, sorry. So there is fundamental rights. We shall discuss now. We shall discuss the questions for citizenship, probable questions. ठीक है जी? We shall start. We have been late 3 minutes, 3 to 5 minutes. So, first question: a citizen of India will lose his or her citizenship if he or she, okay, renounce Indian citizenship, voluntarily acquires citizenship of another country, that is also possible. Marries a citizen of another country, it will not lose. Criticize the government is a fundamental right also. Constructive criticism we can make. So that is not also there. So I mean the answer will be 1 and 2 only. Got it? The answer will be 1 and 2 only. So that will be the answer. Answer will be 1 and 2 only. So that is 1, 2. Next. Question number 2. Citizenship provisions are enshrined in the Constitution. It's very easy. So that is 5 to 11 part. B. According to Citizenship Act 1950, an illegal migrant is a foreigner who enters India without a valid force or travel documents, with valid passport and other prescribed travel documents, but remains in India beyond the permitted period of time. Yes. That will be not an illegal citizen, I think. So 1 and 2. 1 and 2. 1 and 2 only. Yes, 1 and 2 only. That means 1 and 2. Without valid passport and overstays in India beyond the permitted period. Okay. And whether an illegal citizen is not a migrant, so enemy citizen is not there. So 1 and 2. B. Okay, Saroj. Through which way person who is married to a citizen of becomes Indian citizen with resident of India for 7 years, that is registration, and 6+1 categories. The Pravasi Bharatiya Divas started in the year 2003 in New Delhi, and it was observed on the recommendation of LM Singhvi committee. That is A. Which is the way of losing citizenship in India? That is renunciation, termination, and deprivation. D. Easy question. Which of the following is the way of termination of Indian citizen by the central government? Termination. A person shall acquire citizenship of another country. That is correct answer. Citizenship by obtained fraud, that is deprivation. Person who has shown disloyalty, it is also deprivation. And citizen resident outside for 7 years is also deprivation. So answer will be A. Well, we shall move to question number 8. Yes. Then this is termination, not deprivation. Question number 8. Under which article Parliament can regulate the rights of citizens by law? Last article of the Constitution. The citizenship provisions. D. First Pravasi Bharati Divas was held in New Delhi. These are very easy questions. The modes of acquisition and loss of citizenship are provided in Citizenship Act 1955. I told you it's not provided in the Constitution. Okay. The OCI card system was introduced for both PIU and OCI in the year 2015. Now they are called OCI card holders, and they get enjoy a lot of facilities. Only right to vote, right to contest in elections, all these important constitutional provisions are not provided to them. Rather, they are entitled to almost all kinds of facilities inside India. Who is among the empowered to change the political map of India? That is the Parliament of India under Article 3 and 2. It can change. So that is answer C. That is answer B. Citizenship provisions are now applicable to all states and union territories of India after 2019 reorganization of Jammu and Kashmir. It is now that all states and union territories are to be under citizenship provisions. So answer will be A. The Citizenship Amendment Act 29 aims to provide citizenship on the basis of its naturalization, as you know, that reduced to 6 years, 12 to 12 to 6 and 11 to 5. So that will be B. Who was the Prime Minister of India when Aadhaar was launched? That was 2009. So it was Manmohan Singh. Dr. Manmohan Singh was the Prime Minister when a unique identification scheme was launched in India, popularly called Aadhaar. In which of the following general election Lok Sabha the NRIs have been given with proxy? That is provided in 1917 general election for Lok Sabha, that is 2019 to 24 period. So answer will be D. The part containing citizenship in the Constitution of India can be amended by simple majority. Which of the following is not denied to any person of India? Free movement in India, it is a fundamental freedom, that is Article 19. It is not denied to any person. Protection against discrimination is allowed. That is B. Right to contest election is not allowed. There is only citizens. Protection against practice of untouchability. It is also meant for the persons who are citizens. So basically, article against. Oh, sorry. So that is 1 minute. 1 minute. It is article 15. It is article 19. It is there 326. And protection against the practice of untouchability. It is provided. Yes. So it is provided for all. D. D is the answer. Correct answer. Article 17. Which of the following not a condition of deprivation of Citizenship Act under Citizenship Act 1955? Acquisition of citizenship by fraud means is a condition. Showing disloyalty is a condition. Unlawful trading for communication with enemy countries is a condition. Convicted for 2 years within 5 years of naturalization is a condition. Ordinarily resident are supposed 14 years. So 14 years, it is not a condition, it is 7 years. So answer is not option given. Actually, these are not the options. So only answer will be only 5. Or if we reduce, if we delete the word not, then answer will be B. So only 5 if, according to the questions. So that is wrongly written. So answer will be 5. If it is not, then it will be 1 to assembling or any other freedoms. Then he may not have an intellectual growth. He may not be morally sound, and he cannot promote his spiritual enthusiasm because the constitution provides like that. So therefore, fundamental rights are basic, or fundamental rights are called so for 3 reasons. One is their basic human rights, another is they are protected or enforceable by the court, or they are protected by the constitution, and another thing is that they are you like they are like you can say they are essential for the all-round growth, all-round development of the child of a person, material, intellectual, and spiritual. Right? And fundamental rights have been inspired by the American Constitution. It was debated, and as you remember, that there was a committee in the Constituent Assembly on fundamental rights, minorities excluded sections, that was chaired by that is Sardar Patel, and a subcommittee was appointed on fundamental rights also, that was chaired by your J.B. Kripalini. So it means that a special committee, special focus and emphasis was given to fundamental rights in the in the August Assembly, as it is a sine qua non, as they are sine qua non in a democracy. So that is the reason why they are called fundamentals. So our fundamental rights are mentioned in a specific part called Article 12 to 35 of the Indian Constitution. Uh, the inspiration are not only from the USA Constitution but also from USA and UDHR, Universal Declaration. So UDHR, Universal Declaration of Human Rights. That was enunciated on 10 December, declared on 10 December 1948, the day we celebrate International Human Rights Day. And so source of inspiration not only from USA but also from UTHR, because it was declared in 1948 and the codification had already made, and that inspired the Indian makers of Indian Constitution to have an exclusive or elaborate or well-meaning fundamental rights in the Constitution. But the primary source is Bill of Rights in USA, that was added in you can say that is added with the Seventh Amendment Act, and that was there. These rights substantially cover the traditional civil political rights enumerated in Article 2 to 21 of the Universal Declaration of Human Rights. So, if you show that source of Indian fundamental rights are not only Bill of Rights but also the UDHR, which are reflected in the Part 3. Then we shall examine the types of fundamental rights. types, I told you that fundamental rights were treated very special in the constitution, and they are not only well elaborated but also well explained, and details have been provided in the constitution regarding fundamental rights. It is not that they are left to the generations to examine it. It is provided already what types of fundamental rights are required in Indian context. Hence, the makers of the constitution took strenuous effort to prepare a list of fundamental rights, and today we have a long list of fundamental rights. But remember, there was seven fundamental rights at the beginning, which as we have given the list. So today there are six proposals. Let us examine them. So there are constitution in part 3. So I can repeat, the part 3 of the constitution contains fundamental rights. Range of article is 12 to 35, and the various types is right to equality 14 to 18, range of articles. Right to freedom 1922, range of articles. Right against exploitation 23-24, range of articles. Right to freedom is 25 to 28. Cultural educational rights 29-30, and there was right to property, that was 31, and right to constitutional amendment is 32. But this right has been abolished as a fundamental right. They are abolished as a fundamental right, but it is made a legal or constitutional right under Article 300A in Part XI, double I. So now, right to property is not almost, it's completely abolished from the Constitution. It is a fundamental, it became used to be a fundamental right until 78, but now it is considered as a legal or constitutional right. The necessity arose or came to the fore after in order to carry out land reforms and development work in the country. There was a necessity to abolish the status of right to property as a fundamental right. It was essential for conducting or implementing land reforms and land reform provisions, and also for the development purpose. Right to property was not considered a fundamental right, and it is now transferred to or shifted to Part 12, where it is mentioned as a constitutional or legal right. So we can say that we have not lost right to property as a whole. We have lost because India is not a pure democrat, the socialist country. It has both private and public ownership. So private property is also a right in India, and that was abolished by 44th Amendment Act 1978 during the Prime Ministership of Mr. Moraji Desai, the first non-Congress Prime Minister of India, and it was there in 44th Amendment. So now at present there are six fundamental rights. So kindly remember or practice the list of articles provided for each fundamental rights and the name of fundamental rights. And one thing before discussing characteristics of fundamental rights or features, remember that I forgot to tell you fundamental right. Please take a note of this. Fundamental rights origin, you can say origin of fundamental rights can be traced back to Magna Carta, published in 1215 by King John in England. A document containing fundamental right is called Magna Carta, and it is the maiden documentation, is the first or beginning of codification of fundamental rights. Hence, Magna Carta is called the beginning of something. And in America also, after Civil War, prominence was given to fundamental rights in 19th century, and in France also in 18th century, rights of man was codified in the new constitution. So different countries have different times line of evolution of fundamental rights, and India has had a detailed provision for fundamental rights in its constitution after 1947. Okay, that is the thing. So it is the beginning, 1215. Now let us have a brief look at the features of fundamental rights. So we shall deal with exclusively. That is often a question you will find discuss the characteristic features or only features or characteristic of fundamental rights. So fundamental rights are exclusively available to citizens, and some are available to all persons like citizens, aliens, legal persons like corporations and companies. In the citizenship part, we have discussed there are certain rights which are exclusively available to citizens like 40, 15, 16, and 19, and 29, 30 are also meant for minorities in India. Except these articles, all other articles are also available for persons, alien persons, or your aliens, foreigners, and legal persons like corporation and companies. So they are extensive in nature. Fundamental rights are not absolute. Although we have fundamental rights, although we have full freedom, but it is not 10% guaranteed because it is not individual freedom that is more important than collective interest. So, in order to give primacy to collective interest over individual interest in the governance of the country, fundamental rights have not been made supreme or absolute in nature. They are qualified. They are qualified means restrictions can be imposed on the imposition of fundamental rights, and various articles are restricted on various grounds according to their need. We shall discuss each restrictions, but such restrictions should be reasonable and fair in nature. And such reasonableness of the fundamental restrictions are to be decided by the court, especially Supreme Court, High Court. So restrictions are necessary to strike a balance between individual liberty and common interest and social control. That is means individual freedom, individual interest versus collective interest. So which is superior? The collective interest is superior to individual interest. So if in the interest of the larger humanity or larger population in the country, if it is required, there can be a violation of fundamental rights. So for example, 31A, 31C, they are valid even if they violate the provisions. Okay. Then another notable that is fundamental rights promote fundamental rights promote political equality, liberty, and justice. Fundamental rights promote